Legally Speaking. Today's hosts.
Good morning, everyone. Good morning to all the folks who are visiting our city for the Circuit City Classic. We're having a wonderful parade today. I hope that you're enjoying the parade. While in time in the city, hopefully you have a great experience and attend the game today. Of course, the Black Expo, we need your support. And it's important that we support these Black institutions, particularly this day and time in our country. So have fun and make sure you stay safe while you're in the city. Today I have my superstar panel, Attorney Marlon Primes, but I'm going to start on somewhat of a sad note. I been really busy because we're in the litigation cycle now, and when you're doing, I'm involved in some of these police misconduct cases. As you know, we had a series of murders by police officers in 3 months in time period. Police officers shot 18 Black males here in the city. It was just crazy stuff. And I'm representing a couple of those cases. One guy was shot in a tree that was unarmed. The other guy was shot in the back. And what was disturbing them, find out how they investigate these cases are so flawed. It's just terrible in terms of the investigation. And I watched in horror, they were asking the mayor to resign about some women who had some negative conversation, which is inappropriate. Person leaves the office and they want the mayor to resign. None of those folks spoke up about all these young men being murdered by police officers. It was just shocking to me. And my case, we're going to show exactly that's what happened. It was just bad shooting of these young men, and they should be held accountable. But having said that, one of the things that also bothered me this week was an indictment of former FBI Director Jim Coleman. And by the way, I'm no fan of Jim Coleman. Just put this in a historical context. Jim Coleman was FBI Director under President Obama, but he was a holdover. But Jim Coleman was a Republican. And so during the election between Hillary Clinton and Donald Trump, he had a press conference shortly before the election that suggested that he was reviewing Hillary Clinton for potential criminality as it relates to text messages, emails, whatever it was. I don't remember exact details, but he did this press conference. And on that day and time, Hillary Clinton was like 8 points up in the poll, was going to cruise to election and get a landslide victory. She went from 8 points up to 2 points down all within 48 hours. And the mantra on the right became lock her up. And that carried Donald Trump to victory, because even when he tried to retract it a week or so later, it was too late. The damage was done. And it was Jim Coleman who was partly responsible for Donald Trump being elected. Now, the shoe has turned. Trump was upset at him and decided to appoint an attorney named Lindsay Halligan, who apparently had never appeared in a federal court case on a criminal case in her life, and to go and indict Jim Coleman. The problem is a former U.S. attorney said there was not evidence. And basically, so because of that, I guess he got let go. And so she got appointed. And the first thing she did was indict him. And I was going to read to you this indictment because I'll ask Marlon about this, but it seemed like to me this is pretty basic. It says that on or about September 30th, 2020, in the Eastern District of Virginia, defendant James B. Coleman Jr. did willfully and knowingly make a materially false, fictitious, and fraudulent statement in a manner within the jurisdiction of the legislative branch of the government of the United States by falsely stating to a U.S. senator during a Senate Judiciary Committee hearing that he, James B. Coleman Jr., had not authorized someone else at the FBI to be an anonymous source in news report regarding an FBI investigation concerning person one. Number two, that statement was false because as James B. Coleman Jr. then and therefore knew, he in fact had authorized person three to serve as an anonymous source in a news report regarding an FBI investigation concerning person one, all in violation of 18 U.S.C. 1001A2. Then count two dealt with obstruction of congressional proceeding, and basically he did corruptly endeavor, influence, obstruct, and impede the due and proper exercise of power of inquiry under which an investigation was being had before the Senate Judiciary Committee by making a false and misleading statement. And now this was only signed by Lindsay Halley, not the people who normally work there that will sign this, but by the person who just got appointed. So if you're concerned about us having a constitutional crisis, this is evidence front and center where the President of the United States appoints someone for the specific purpose of indicting a person he doesn't like. Marlon, your Justice Department, it sounds like they're now becoming the Department of Injustice.
Well, hey, good morning, everyone, and good morning, Nathaniel. This certainly is a sad day for our country and a sad day for many of us that are alumni at the U.S. Department of Justice. The department has never been perfect, there's no institution that is, but there were recognized norms that have been breached. There is a key statement that there's prosecution without fear or favor, which basically means in layman's terms that you're going to be even-handed as relates to the administration of justice. And to have a president of the United States weigh in on the judicial system really violates accepted norms. That's supposed to be separate and distinct from the White House. So to have the president involved in saying that these individuals, Comey, former FBI Director Comey, and others, not only should be indicted, but were guilty, that are guilty, is certainly an affront to the system and certainly a low day, for the Department of Justice and also for our system of justice. There should be an independent determination as to whether or not, someone should be indicted. Federal prosecutors have tremendous authority in our system. They have the authority to basically ruin reputations. And so there are, accepted norms at the department that you're supposed to present, information that would show somebody is innocent. And what's also problematic, we don't know if that was done in this case, what's also problematic, not only did the prior U.S. attorney say that there was insufficient evidence for an indictment, the allegation was that he was going to be terminated for his legal determination that there wasn't sufficient evidence for an indictment. What's also problematic, which is part of Department of Justice norms, is that there was a memo circulated by career staff. These are people that perhaps have been at the department for years, have indicated that, hey, not only was there not enough evidence for an indictment, there wasn't even enough evidence for probable cause. So that should cause any reasonable prosecutor to pump the brakes. And then finally, you have somebody that isn't experienced in this area. Criminal law is very complex, and to have someone that is hand selected and then doesn't have the experience is very, very troubling. So these are very, very difficult times that we're in, Nathaniel. And, I think that your listeners, your audience should be aware of that as well and not, take anything that's kind of coming out, that this is just normal and the other side doesn't. No, this is a very grave departure from recognized standards, and it's something that we should all be alarmed and concerned about.
Well, the other thing that's important about this is that you have a guy, Jim Coleman, that probably has some wealth. I'm not sure what his financial situation is, But the first thing they did, I know he went out and hired one of the top trial lawyers in the federal court system in the country to defend him. The average citizen don't have access to that type of attorney, in the sense that this federal type practice of this level is kind of a specialized practice. You're dealing with complicated federal statutes in the process. It's different than a lot of times you see in the state court system. So just because you could be a great trial lawyer in the state court, criminal court system, may not make you a great trial lawyer in the federal system, because the rules are different. Like in federal court, for example, when you try cases, you cite evidentiary rule. In state court, you might say hearsay. In federal court, you say 803. So there's some different trial practice, because I've tried cases in both forums. And in the state court, for example, when you're doing jury trials, from state to state it varies, but one constant is that they generally allow you to talk to jurors. In federal court, not the case. I have to fight like hell to get the judges to let me do part of the voir dire in federal court. So it's a different process. And my concern, Marlon, is that we're dealing with a situation whereby there appears to be a targeted hit list of people that the current president want to have prosecuted. And it's publicly known, which means that they're talking about this. The papers can't just manufacture this. And I'm concerned that this is something that maybe you do happen in communist countries like Russia and places like that, but never in the history of the United States have we have anything like this before. Not in my memory, Marlon. I don't remember at any time in American history that we ever had a president out himself trying to prosecute people and take over the Justice Department. It's insane.
It really is troubling. And part of the reforms following the Watergate scandal, and that led to the resignation of President Richard Nixon, was that they wanted to make sure that these very powerful arms of the federal government, the Internal Revenue Service, the Department of Justice, were not weaponized. And that was kind of part of the concern as relates to Watergate. And so the fact that we don't remember and we don't adhere to a lot of those reforms are very problematic. And what is really troubling to me is that, it seems to me that, there are some things that we can agree to disagree about. But I'm just concerned that as lawyers, many of our, federal legislatures are lawyers. They should know better that, a president cannot weigh in on a pending case or indicate someone should be indicted. Kind of reminds me of, your listeners are probably, familiar with Alice in Wonderland, and the Queen famously says in that play, no, first the verdict, then the trial. And it's absurd, and it just was a reflection of the fact that there was unfairness. And you would never think that that would occur, within our system of justice, that somebody would be the judge, jury, and executioner, prior to someone being accused or being indicted. So it's certainly very, very problematic. And I think something that, more people should be publicly outraged about. And I just warn, individuals that, hey, this is dangerous stuff. If you allow this, what's to say that a Democrat gets in office and tries to do the same thing? You can't allow this to happen and not say anything. It's so dangerous to have the organs of government weaponized. And so it's something that we have to understand there's a clear and present danger to our public. And finally, I'll just say, the U.S. Department of Justice has been the gold standard for decades. And again, it's not perfect. There were certainly, there has been problems, but, prosecutors from the U.S. Attorney's Office go around the world and train other lawyers all around the world about the system of justice, the rule of law, how important it is, and they preach these norms about, not, trying somebody in the media, making sure that there's, proper information being submitted to the grand jury, fairness. And, how do you have credibility in those forms when this behavior takes place? So it's very, very disconcerting. And I'm thankful that you're seeing a lot of DOJ alumni on the air that are, raising a lot of red flags. But I'm just a little concerned that there's not more unanimity, that this is certainly very problematic. And that's, very concerning to me.
Well, my concern also of the highest level is that political pundits are saying that this uh, is a major distraction or represent a departure from the Epstein file issue. And then I'm thinking you would start knowingly violating state and federal laws, and then to protect that, then I double check the statute of limitation. The reason why I guess it's such a big deal is I saw where they eliminated the federal statute of limitation to prosecute people for sex crimes like this. So there's not a statute of limitation anymore. So the information once released, if it exposes folks apparently to sexual misconduct with minor children, that they can be prosecuted. And for example, the president himself would not be immune from that prosecution because that would have occurred long before he was president of the United States, I suspect. And so, but the more important thing, Marley, is that where do we get to a society where these elderly men think it's appropriate to have these physical relationships with these teenage girls? I don't get that. And if the motivation for this chaos is to prevent production of this Epstein file, then it should be outrage across America. It shouldn't be Democrats or Republicans. It just should be human beings. And I'm concerned that this will not end until there's some type of vote to release this file. If somebody did some misconduct, let them be held accountable. But I was surprised, Marlon, that the statute of limitations for these have been eliminated. And so now the child rape thing is just as the same type category as murder, I guess. It's no statute of limitation.
I'm, as a father like you and, us both, we have daughters and sons, that, obviously we're very concerned about, any minor, that's abused. I mean, it's a huge crime for any adult to violate, anyone, especially, an individual that, is underage, because, that's just trauma, and trauma is very substantial. But the thing I think that we need to really kind of focus in on in terms of the statute of limitations that I'm concerned about is that we have had uneven justice in this country, especially as relates to, crimes regarding sexual impropriety. So at one hand, I believe that people should be held accountable, but if it's an unlimited statute of limitations or it's too long, people don't have an opportunity to defend themselves. Memories fade. And that's the whole reason why we have a statute of limitations. And basically what that basically means is that there's a time limit in terms of bringing certain claims. And there was an extension of the statute of limitations, regarding, some sexual misconduct. And I understand that, but we have to just be careful as a society that the pendulum doesn't swing too far, so that, a person isn't able to defend themselves. The witnesses are gone. The evidence becomes stale. So we have to really keep our mind on that. The whole thing about Epstein as well, there was a lot of push, for the release because it became, standard dogma in a lot of the conservative media that somehow, high-ranking Democrats were involved. And that's why I think there was such a great push. And then when there's allegations that others that weren't Democrats were involved, then it seems many commentators have, indicated that there seemed to be a pumping of the brakes on that information. So the final thing that you want to just be careful of, something I've said before, is that anytime you have grand jury material, you want to be very, very careful about releasing that, because what that basically means is that, it's any information. It can be hearsay. Someone says that Nathaniel has done X, Y, and Z. The grand jury could have hearsay on top of hearsay. Or I heard someone said that you did X and such. And so if there isn't an indictment, we don't want that information out there, because the whole secrecy of the grand jury process is to ensure that if a person isn't indicted, their reputation isn't harmed. So we have to be careful about that as well, because that can be weaponized. And that's why I think you got some pushback in terms of the releasing of information by the federal court refused to do so. So it'll be interesting to see how this thing progresses.
Well, one of the things that fascinated me was Epstein apparently had a substantial amount of wealth, and they were saying that there's a booklet that contains all this information. And I noticed that Chase Bank had made a major settlement with these victims. So I'll be interested. Now it's kind of got my attention. I'm just sitting on the sideline. I'm interested to seeing exactly what's in this booklet. Even though I'm not in the criminal law areas, I'm thinking that there's something that may be fascinating, and be interested to see whether or not he documents in a booklet misconduct. Just fascinating stuff. But the one thing that's critical, though, is that the Jim Coleman indictment certainly changed the political climate. The political pundits on TV weren't talking about that. They were talking about Jim Coleman. And I watched them talk about whether or not they're going to send the FBI and raid his home and arrest him and do the perf walk with him. And I saw where they worked out a deal where he was going to surrender. But I was concerned about the indictment for another reason. The indictment itself was very simplistic in terms of how it was written. And I read that because I've seen some indictments, they're like 100 pages, and they have very distinct language. They specify federal statute, and then they explain why the person is being indicted for that particular federal statute. I assume that one of the other avenues that the defense lawyer would do would probably file a motion to have them clarify the language in the indictment. And is that called what, a bill of particulars in federal court, Marla? I can't remember the term.
The bill of particulars is asking for discovery, and so that's something that's standard that is done. But there's just a lot of very unusual things. Now, if you look at the actual indictment, the question is whether or not there is a material misstatement of fact. All right, and then you have to have a guilty state of mind. So there are some questions as to whether or not the indictment, meets those very, very high standards. It's not more likely than not, in order for there to be a conviction, it has to be guilt beyond a reasonable doubt. So certainly, it's problematic. And then if you really kind of, peel back the onion, this concerns an allegation as to whether or not a leak regarding Hillary Clinton was authorized. And the testimony that they're, circling as the basis was when, Director Comey was questioned by Senator Ted Cruz from Texas. And, Director Comey says, hey, my prior testimony years earlier or sometime earlier is accurate. So, there's a question of whether or not this meets the statute of limitations. And then the other thing your audience should know, there was an independent counsel report that basically indicated that they thought that Comey was accurate as it relates to the issue of whether or not there was an authorization of a release of information. And it involves the deputy at that time, Andy McCabe, and the report from the Inspector General indicated they thought Comey's testimony was more credible than that of Andy McCabe. So there's going to be some substantial hurdles, I think, in litigating this case. I think you're going to get a motion regarding selective or vindictive prosecution. And I think, the tweet, not or the statement on social media by the president is certainly going to be Exhibit A as relates to selective or vindictive prosecution. So there's a possibility this case could, in fact, get dismissed even before it goes to trial.
Yeah, one of the questions that Pierre asked Marlon, he said the judge will or should dismiss it once the defense file that motion. What will the defense file, Attorney Prime? He said, in other words, what motion does it need to file and why?
Yeah, well, I would file a even though these are hard motions to win generally, because generally you're not going to have an internal communication. So what happened on Truth Social, which is President Trump's social media platform, he seemed to be sending a private message to the Attorney General Pam Bondi that Comey should be indicted and that he is guilty. So it suggests that there's some vindictiveness in selective prosecution. So that's going to be, an issue. The other issue that you raised earlier, you have two different versions of the indictment. Which one is it? And did they actually get the requisite number of grand jurors to make a determination as it relates to an indictment? So that's going to certainly be problematic and something that I think the defense attorneys will attack very vigorously. The other thing that's going to be very interesting is that it's very rare that the U.S. attorney is involved, with the grand jurors, usually an assistant U.S. attorney. But in this case, it seems as though nobody else wanted to be involved, which says a lot about the credibility of the indictment and the procedures. So there's going to be a lot of motion practices going to be filed. It will be interesting to see, what the federal court in fact does.
Well, okay, Pierre, to answer your question, the indictment that I read showed that the alleged event that resulted in the indictment occurred on September 30th of 2020 is a 5-year statute of limitations. So September 30th at midnight, the statute of limitation would have run the 5-year statute. And so I'm thinking that that's why she hastily put this together to come within what they perceive to be the statute of limitation, which may be debatable in the sense that the testimony happened sometime before and they were asking a simple question, do you agree with what he has said? So it's going to be interesting to see how that shakes out. Now, moving on, let's talk about the status of what happened in our state and across the country. There's this constant attack on DEI, affirmative action, and things of that nature. Each day we see people being hauled away by ICE, Border Patrol, people like that. But what we're not talking a lot about is something that's close to home. The unemployment rate this month rose up to 4.3%, which on the surface is not too bad. But the problem is the United States is not producing enough jobs. So that means that statistically it's going to go up each month. But the real problem is Black unemployment. Black unemployment is up past 7.5%. And that's really high. We consider the fact that the culprit of this surge in unemployment are Black women, African-American women, and a lot of time they're head of the household or the primary wage provider. So when you factor that in, that 7.5% will probably affect about 15 to 20% of Blacks in America. And because of that, uh, we're heading into a crisis in our community. Marlon, we had a situation here in Indianapolis this week that just sickened me. There was a data center that was going to invest billions of dollars in the city of Indianapolis to build it on the southeast side of Indy, right? And people came out to protest this data center. And I was watching this on TV. I'm thinking, what is wrong with these folks? If you don't have these type businesses in the city, we don't get jobs for our community. So the Black unemployment rate will get higher by not having this access to jobs. Back 30, 40 years ago in Indianapolis, we had all these factories in our city, and these factories provided high-paying jobs for a lot of African Americans. Those factories are gone. And so the corollary of that is that we see a sharp increase in crime or criminality because of job. So the point of that is, as we see the Black unemployment rate continue to increase, there's a correlation between criminality and unemployment. You know, you see an increase in community where you have high unemployment rates. And so we need to somehow take a close look at this and collectively try to figure out what can we do to prevent this tide, Marlon.
Yeah, I couldn't agree more, Nathaniel. And the other thing that I think your audience should be aware of in terms of the Black unemployment rate is many of you may remember, the president and Doge, they basically offered a lot of these buyouts for federal employees, and they indicated that if you resign, you will be paid through what date? September 30th. So there's going to be an uptick in unemployment because a number of those individuals, according to reports I've read, have not been able to secure employment. So I think you're going to see an even higher tick. The other thing that's really important for the audience to recognize is that we have to educate ourselves, and we have to educate those in our circles about a lot of this misperceptions about DEI, diversity, equity, and inclusion. The popular narrative by the administration that somehow DEI basically means that underqualified people are getting jobs, and that could be nothing could be further from the truth. What it is actually doing is it's basically indicating that you're going to provide job opportunities. In other words, you're going to recruit in non-traditional areas in Indiana, or you're going to go to schools that might be predominantly minority that you may not have recruited at in the past. I mean, that's what basically it means. It means that you're opening up a wider net in terms of the pool of applicants. And, as a result of the federal government and local governments doing that, you see a larger percentage of our people that are working these government jobs. So when the government cut back, this has an impact on Black employment. So it's something that's very, very problematic. And then I think your final point, as it relates to crime, you're absolutely right. And, statistically, we look at the fact in the 1970s, we had about 300,000, people incarcerated. And now at the turn of the last century, we had, close to 2 million, because the overcriminalization of our justice system. Instead of, getting treatment for people that are, addicted to drugs, whether it be crack or whatever, we decided to criminalize that. And I'll note that it's very different than what you're saying, what happened with the opioid crisis. They treated that as a health emergency, and you didn't see the overcriminalization of that. And so as a consequence of somebody getting that conviction on your record, it makes it more difficult for you to get a job opportunity. And there was an overemphasis of that criminalization in the African American community. So not only do you have this situation in terms of the expiration of payments under DOJ, you have the overcriminalization of our system, you have the attack on DEI. So there's a lot of different factors at play, which I think, play a role in, the African American unemployment rate, creeping, higher.
Well, the process, though, of what most people don't also recognize, appreciate, is the history maybe of segregation in our country. And Marlon, affirmative action, I went to the University of Georgia Law School, and the University of Georgia, in my mind, always had affirmative action, but it was different. The affirmative action they had, if you're white, wealthy, politically connected, you got into the law school. And the only time that became relevant to Blacks were like in the 70s, and I ended up going to law school because in order to have fairness in the process, we were able to get scholarships. And the law school reputation actually didn't decrease, it got better. Our trial team won national championship, our moot court won national championship, and we became one of the best trial schools in the country. Beat all the schools, Harvard, Yale, you name them. Beat them all in competition, trials and things like that. And so the point of that is that most people probably don't realize that the affirmative action that they're attacking only benefited certain people in the past. And now that it became available to Blacks, then it got criticized. Now we see in our state, I can't go a week without some politician now attacking DEI like it's a dirty word or something. And it's just pathetic in terms of these attacks. Now we'll go to the lines because I see our lines heating up. Oh, Imhotep, you had a question or comment for us today, sir.
Yes, good morning. Good morning, my great people and legal scholars. I really appreciate you all for touching us with the legal stuff. I just got one question and two comments. One, I just read a piece this morning from the LA Times, I think it was, that Clarence Thomas decried yesterday that legal precedents are not the end all and be all. And I guess we can definitely see that with the Dobbs decision and affirmative action decision and others, but he just felt that he had to make it a point to get the public to understand that legal precedents basically mean nothing. And number two, the question is, my mother was telling me yesterday she's excited and anxious to hear this Supreme Court ruling on the tariffs. As you know, Trump announced new tariffs yesterday, 100% on pharmaceuticals, 50% on cabinets and bathroom furniture, 30% on upholstered furniture, and I think it was 25%, it could have been 50% on trucks, heavy trucks, or maybe 25% on heavy trucks. Very, very deep tariff. So your opinion or your analysis, or what do you think about this tariff case from this Supreme Court we got? Because Elena Kagan wrote a scathing decision the other day with the 6-3 decision. I think it was on the FTC lady giving Trump the power to fire the FTC person. She wrote a scathing decision, but this tariff decisions they vary here or are hearing. I'd like to hear your analysis on that. And here we go again. Thank you for taking my call.
Well, I think it's certainly going to be very interesting. And I think your audience should be aware of, when President, Biden was in office, the Supreme Court created a new doctrine called the Major Questions Doctrine. And what they were basically saying is that, as it relates to, some of the initiatives that President Biden was pushing, they were saying that, hey, this is such a substantial issue. There should be, you should get some weigh in from Congress, the legislative branch. All right. Now, juxtapose that to what they're doing now when President Trump is in office, and they're pretty much in Justice Ketanji Brown Jackson's words, they're playing Calvin ball, and she says that, hey, what that basically means is that irrespective, the president wins. So we got to really pay attention to her comments, because she's someone sitting at the table and she's, hearing the discussions, and she's saying that, hey, it's not even-handed. So we have to really pay, very close attention to not only her dissents, but the dissents of Justice Kagan and Justice Sotomayor. And then finally, I'll just mention that's really important is that there really hasn't been, a proper dissemination of information, in my view, about, tariffs and just the decisions that have a wide impact on our overall society. One of the things that people haven't, talked about enough, and it impacts Indiana and a number of our Midwest states, is the question of soybeans. When you put these tariffs on, there's a lot of farmers in the Midwest that lost money. I mean, this was they were selling a lot of these soybeans to China, and this was just automatic money that they could use to pay their mortgage. They could use to buy, tractors, parts. And what China basically did is they cut their soybean purchases down to zero and went to Brazil. And in terms of, cattle and beef, they just signed a major trade agreement with Australia. So, these are things that are going to have a big impact on our overall society. And we're also seeing now a lot of farmers throughout the Midwest that are saying, hey, look, hey, this was something that I counted on in terms of money in my pocket. And now these opportunities to sell soybeans, sell beef, sell other products are now gone. And we're seeing the same thing in the automobile industry. We're seeing the same thing, regarding, our supply chains. And a lot of companies are, putting the alarm bell saying that, hey, they're not going to be able to stock shelves because of this. So it's something that we need to really pay attention, and it's something that we need to educate our communities about, that, hey, these tariffs are paid by us, by the consumers, are passed on, and they have a negative impact on our overall economy, especially as Midwest states like Ohio, Indiana, Iowa. And so they're not meaningless processes, policies. And finally, you have, it's just like Nathaniel, you have a designated customer or client that gives you business, and you put that as part of your budget. And as a result of, the policies of the administration, that, major source of income is gone overnight. So that's what's happening across the country. So in answer to your question, it will be interesting to see what the Supreme Court does what I want you to pay attention to is, will you see the majority invoke the major questions doctrine as they did with President Biden regarding climate change and a number of other things, or will they just basically say, hey, you can go ahead and do it?
Well, you know what? Let me make something clear to our audience. This is something basic that we should have learned somewhere in our education process, whether it's elementary, junior high, high school. And that's this. The United States has a constitution. Article 1 of the United States Constitution that's been around for centuries, it's Section 8, the so-called taxing and spending clause of the United States Constitution. So this is not rocket science. The Constitution grants Congress the exclusive authority to levy taxes and duties. So only Congress, based on our United States Constitution, has the power to levy taxes. Tariff is a form of tax. So it's shocking to me that the U.S. Supreme Court would even want to entertain discussing this. What the justices plan to do what is overthrow the Constitution of the United States. This is such a clear evidence of what a dictatorship could look like. So if the Congress eliminates his ability to exercise its constitutional powers and duties and responsibility, then that represents a departure from democracy. So I don't even think this is an issue that's closed. It's unambiguous, and so I'm just surprised that a lot of people talk about the Supreme Court over accepting this. I'm thinking, well, how could they? Even if they're highly politically partisan, this is such a clear example of what the law is, and I can't imagine it being more clear. Tariffs are taxes. Tariffs are taxes on American taxpayers. So every time you buy goods that are subject to a tariff that's paid by the retailer, you're paying the retailer for tariffs that he or she has paid for. So that's a tax. And the tariffs have never worked in American history. Just a reminder, tariffs started in this country back in the early 20s. And a lot of people, economists, thought that tariffs was the agency or the process that caused the Great Depression. And a lot of people dispute that, but everybody agreed that the tariffs made the Great Depression last longer. So all your respected economists, they would agree to that statement. So the tariffs has never been something that really have elevated the United States economy. It's a tax on working people. Now, give you a good example, Marlon, you're talking about inflation. Let me tell you what these tariffs have done. A year ago, I went to Costco to buy steaks, and I try to buy a small quantity of steaks, and they sell in bulk quantities. So the smallest one I could get was a package of 3 ribeye steaks, 3. The packs of 3 ribeye steaks at Costco in 2024 cost me about $24, which I thought was high. Yesterday, I went to Costco. Those same 3 steaks cost $82. I said, what? $82? You're talking about inflation. And then I looked into why there was such a dramatic increase in these ribeye steaks. So I did some research. Well, it turns out that we were getting 25.7% of our beef from Mexico. We put on tariffs. Now there's a smaller supply of beef, and now the price is not just double, but it's triple in that short period of time. So now the average person are paying higher prices. They're struggling to pay their bills. They're living from paycheck to paycheck. And now you get hit with these exorbitant prices. And I think that that's something that people have to consider. And I'll talk about the solution to this, but the thing I want people to recognize is that we're in trying times now when you could have that dramatic increase in a food item, even though the steak may seem a luxury item. I mean, but if you're a meat eater, every now and then you want a good steak.
Right. Well, I think I agree with that. And I think, the through line between what we're talking about in inflation, is that, a lot of these issues that are brought to bear are really an attempt to divide us, to really stop focusing on those key issues, those standard quality of life issues. I mean, the reality of it is that, we're more alike than we give ourselves credit. We want to educate our children. We want them to do better than us. And that's true, across religions, across races. And when we get focused in on issues, immigration and some of these other ancillary issues, it really distracts us from where the focus should be, about our quality of life, our standard of living, making sure that our children and our children's children have opportunities that we don't have. So it's really problematic. And I think it just kind of goes without saying that, we really need to, get ourselves educated, educate others. I mean, you have a very educated audience, but educate others about these very important issues, and just making sure people are registered to vote, know their voting places, and then when you get an opportunity to speak to politicians, raise these very important issues so that they're addressed.
Yeah, it's very important. And now, Milton, we've had several texts. They want to know about the United States Supreme Court shadow dockets. Are the shadow decision mostly just putting a temporary hold on cases until the case goes before the Supreme Court of the United States?
Well, the shadow docket is really, problematic, and what that means is that normally a case goes through the three parts of the federal system, or through the state system. So is a trial court, the district court, the federal appellate court, and then the Supreme Court. Or if it comes from the state system, it usually comes from the state Supreme Court, and there's what's known as a writ of certiorari, and that gets granted by the Supreme Court. Then both sides get an opportunity to fully brief and argue. So what's happening in the shadow docket is that it just puts that whole process aside, and decides a case without there being full briefing, without, in many instances, there being a full oral argument or full reasoning. Now, it used to have this temporary docket that would take place, in execution cases where there was a determination as to, someone's Eighth Amendment rights were impacted, and whether or not, an execution should go through, because that really is an emergency. The Supreme Court is really putting this on its head and saying, the emergency is that the administration doesn't get what they want. And that's a far cry from where we saw, these emergency dockets used in the past. So it's really troublesome. A lot of the federal district court judges are really revolting and saying, hey, they don't understand, what the rationale is, and they really can't conform themselves to complying with the Supreme Court decision because they don't understand the reasoning. And, what's also problematic, and I'll say just very briefly, is that it's almost as if the federal Supreme Court, U.S. Supreme Court, is almost, acting as a district court and deciding all these cases and giving the administration the green light to continue on policies that many district courts have said violate the Constitution. They violated such a degree that they put temporary holds on it. And the Supreme Court comes in and says, no, we're going to release that hold, and we're going to do it on an emergency basis without there being full briefing. So that's what, Ketanji Brown Jackson, Justice Sotomayor, and Elena Kagan are screaming about, that these important issues about, freezing, international aid, some of these other major issues, those shouldn't be decided on the emergency or shadow docket. They should let them go through the federal system, the district court, the appellate court, then the Supreme Court, and then the Supreme Court weigh in where there's full transparency.
Hey, do you think that when we're making wide use of this shadow docket, Marlon, that it undermines the faith of the typical American citizen who watch this and think that maybe the court has become corrupt, or the court is not acting in the best interest of American citizen? How does that give faith to the Supreme Court? I wonder, what are your thoughts on that?
It really doesn't, and it's certainly problematic. And I think, there's a famous Supreme Court decision that says, hey, unlike the other branches of government, we don't have an army. We have to persuade individuals that, we're fair based upon our rulings and our consistency. And so when you don't have that, when there isn't consistency, when they're not following precedent, it really causes people to wonder whether or not the court are neutral arbiters of the Constitution and calling balls and strikes as they see them. So it certainly raises, tremendous questions. And, one of the things on this very point, the Justice Sotomayor was on a lot of local media, regarding the recent decision whereby the Supreme Court indicated that race can be taken into consideration in detaining individuals, for immigration offenses. And so there are a lot of concerns that on one hand, the court is saying, hey, you can't take race into consideration in admissions, and to help African Americans that have been subject to decades of discrimination, but you can use race to detain individuals regarding immigration issues where that could possibly impinge upon their federal civil rights. So there are some very, serious questions, and not only are those questions being, raised by legal pundits. These are questions that are being raised by Ketanji Brown Jackson, Justice Sotomayor, and Elena Kagan. So, we have to really pay attention to those dissents to really get a bird's eye view of what's happening, because they are there. They have a front row seat.
Well, I'd like to thank our guests, both on the internet that sent us text and to call in for today's show and comment. Of course, Marlon always does an outstanding job. Next week, we're going to change course slightly. I'm going to start talking about some solutions to some of these issues, particularly civil rights issues, as they're doing this blatant attack on the benefits and privileges that we've fought to achieve, and we're seeing a dramatic rollback. So we'll start a discussion on what are some of the specific things we could do to counteract those. So join us next Saturday as we deal with legal issues of the day. Thank you all, and thank you for joining us, and have a great time this weekend in Indianapolis, everyone. Be safe.